Today, Americans might point to the Bill of Rights as an example of their most cherished liberties. 250 years ago, Americans also referred to a Bill of Rights, but they meant a 1689 English document. Over 2 centuries, the Bill of Rights transformed. This history underscores the continuity of a culture of rights and liberties as bulwarks against power. But it also reveals the challenges that arose as rights developed under a monarchical constitution were replaced with rights within a free constitution of the people. During struggles against the Stuart kings in England in the 1600s, rights and liberties developed as concepts to limit government power. Magna Carta began to be interpreted as a fundamental charter, limiting the monarch and assuring liberty of the person, trial by jury, habeas corpus, and due process. In 1689, after the Glorious Revolution and King James II's abdication, a national convention drafted the Declaration of Rights. With royal assent, Parliament then enacted the Declaration as a bill, which declared ancient rights and liberties in response to parallel grievances about the king. The Declaration of Rights and Bill of Rights created a new genre of constitutional instrument involving rights and liberties, with certain declarations limiting the Crown. It could not suspend or dispense with laws, tax without parliamentary consent, or prosecute subjects for petitioning. This culture of rights and liberties operated also in the American colonies under colonial charters, guaranteeing the rights of Englishmen, and was later embraced by Congress during the American Revolution. In 1776, the Declaration of Independence first declared that all men are created equal, with unalienable rights, including life, liberty, and the pursuit of happiness, and then listed the king's repeated injuries and usurpations to rights and liberties. As the states drafted instruments forming constitutions as free governments of the people, 2 rights repeatedly appeared. The vast majority included guarantee of a jury trial in criminal cases, and most recognized religious liberty. But in other respects, there was little consensus. At the Constitutional Convention in 1787, delegates focused primarily on the structure of the proposed new government, rather than on rights and liberties. The first draft of the Constitution included freedom of speech and debate for congressional members, a right to a jury trial in criminal cases, and state privileges and immunities. In late August, the convention inserted additional rights, including habeas corpus and a bar on religious tests for office. On September 12th, a proposal for a committee to prepare a Bill of Rights was presented, but the delegates unanimously rejected it. Historians speculate that the delegates wanted to be finished. Divergences among the states over specific rights would have sabotaged the completion. By August 1788, the Constitution had been ratified by 11 states, but the absence of a Bill of Rights remained controversial. State conventions sent recommended amendments with their ratifications. 6 proposed additional rights, or a recommendation of rights. James Madison initially opposed the addition of a Bill of Rights to the Constitution, but after failing to be selected as a U.S. Senator, he publicly changed his position on amendments to win election to the U.S. House of Representatives. As a member of the first House of Representatives, Madison advanced a lengthy group of amendments to the Constitution. He drew on amendments offered by the state ratifying conventions, but ignored the many proposed amendments which sought to fundamentally alter the structure of the new federal government. Madison's proposals diverged from state recommendations in important respects. First, so that the list would not disparage those rights which were not placed in that enumeration. He included a provision, now the 9th Amendment, which stated that the list of certain rights was not to diminish the just importance of other rights retained by the people. Second, desiring protection against abuses of certain rights by both the national government and state governments, Madison proposed the following amendment. No state shall violate the equal rights of conscience, or the freedom of the press, or the trial by jury in criminal cases. Third, he included a clause that protected property from being taken for public use without just compensation. Congress significantly altered Madison's proposal, and his suggestions were redrafted by committee. The House sent 17 articles to the Senate, which rewrote and regrouped the list. It also deleted a number of amendments, including the provision providing for prohibitions on the states. On September 28, 1789, 12 amendments were transmitted to the states for ratification. Ratification proceeded slowly, but on December 15, 1791, Virginia was the 11th state to ratify the set of amendments that we now know as the Bill of Rights. On March 1, 1792, Secretary of State Thomas Jefferson announced that the 10 articles had been ratified. The contemporary American understanding of the Bill of Rights is a product of the 20th century. From the late 19th century, the Supreme Court used the language of the 14th Amendment to gradually permit some of the rights to be used against state actions through a process known as Incorporation. Rights related to property, the First Amendment, and certain criminal procedure rights followed. In the 1960s, the court incorporated the vast majority of the remaining enumerated rights, and in the 21st century, the Second Amendment was incorporated. While we may disagree passionately about the content of rights and liberties, and whether various actions of the government violate them, our culture of rights and liberties continues to serve an essential role against encroaching power and reminds us that government is founded by the people.